HarperCollins and Harper Audio present Overruled, The Human Toll of Too Much Law by Neil Gorsuch and Janie Nitze. Read by Neil Gorsuch and Charles Constant.
For the men and women whose experiences are recounted in these pages. Those who won our independence by revolution were not cowards. They did not exalt order at the cost of liberty. Justice Louis Brandeis. Prologue. But the plans were on display. On display? I eventually had to go down to the cellar to find them. That's the display department. With a flashlight. Ah, well, the lights had probably gone. So had the stairs. But look, you found the notice, didn't you? Yes, said Arthur. Yes, I did. It was on display in the bottom of a locked filing cabinet, stuck in a disused lavatory, with a sign on the door saying, "Beware of the Leopard." Douglas Adams, The Hitchhiker's Guide to the Galaxy. About a year before it moved across the street into its own building, the Supreme Court gathered, as it had for more than 7 decades, to hear argument in the old Senate chamber in the Capitol. There, the justices confronted a curious problem. Is there any official or general publication of these executive orders? Justice Louis Brandeis asked the government lawyer at the podium. Not that I know of, the attorney replied. The hearing that day concerned charges against 2 firms. Government officials alleged that the companies were busy producing more oil from fields in East Texas than a federal quota allowed. The only trouble was, no one could seem to lay hands on the executive order containing the production quota that the companies had supposedly flouted. Well, is there any way by which one can find out what is in these executive orders when they are issued? Justice Brandeis pressed. I think it would be rather difficult, the government's lawyer answered. When his turn at the podium came, one of the company's lawyers, a portly, red-haired man with a frontier manner of speech, told the court that the only set of rules he had ever seen had come from the hip pocket of an agent sent down to Texas from Washington. Newspapers reported that even the normally staid Chief Justice, Charles Evans Hughes, couldn't help but crack a smile. Other justices enjoyed a good-natured chuckle. Later, the government's lawyer told Congress that his staff had looked everywhere. They had found plenty of rules governing the company's activities, but they never did get to see the original of the executive order at issue. The best anyone could muster was a copy, and it turned out to contain no production quota at all. As the court wrote in its judgment, it appeared that the case against the 2 companies had proceeded through the entire judicial system upon a false premise, a government mandate which did not exist. I used to think the hip pocket incident a quirk of history. For some time, federal officials had resisted publishing their regulations for the public, arguing that the government wasn't in the newspaper business. But Justice Brandeis had long urged more transparency, and some say his questions at oral argument sealed the deal. Soon afterward, the government agreed to create the Federal Register and publish there every new regulation it produced. Fast forward about 80 years. I was sitting as a judge on the Federal Court of Appeals in Denver. The federal government had accused a Kansas home health care company called Caring Hearts of fraud. Never a light matter, a charge like that threatened the firm's future. For 6 years, the dispute had dragged through layers of administrative and judicial appeals. By the time it made its way to my court, Caring Hearts had lost at just about every turn. But as my colleagues and I dug into the case,
Sample complete. Ready to continue?